Hi guys, this is Cherrelle along with Jennifer and Robert, and our research topic is on premises liability in Tennessee. The question we're going to be answering in this video is, in Tennessee, if a fireman enters a business to investigate a carbon monoxide alarm and falls through a weak floorboard and breaks his leg, can the fireman sue the business owner?
Thank you, Cherrelle. This is Robert, and I just wanted to go through and do a little bit of research with you. Show you how we did our research, and we kind of initially uh, brainstormed, did some brain mapping, and trying to figure out some really good Boolean search terms. And essentially, what I did uh, initially is I did like what everybody else would do when I'm looking for a topic. I actually Google it, as funny as that may sound. And my search term within Google was, if a firefighter is injured in my business responding to an emergency, could I be held liable? And I thought this was interesting because it brought up a lot of different websites. I didn't think this would even be that big of a topic. And talks about workers' compensation issues. And really looking through this, I don't want to spend too much time on this, but with plaintiffmagazine.com says recent issues, and the article is protecting first responders from abuse of the firefighters rule. And I've never heard this term, so I kind of opened this up and I was reading through it. And basically, this mostly has to do with law in California. So it's not binding law for Tennessee. Um, uh, but I liked the fact that it gives you really the firefighters rule in generally. This applies basically in almost every state within the U.S. And I found this actually article very interesting. It talks about public policy, and the policy being that in most states, a firefighter can't recover for injury from a business. Basically, if there's some type of inherent danger that the owner knows about, um, sometimes they can't recover for that. The different circumstances behind that. Now, California has its own set of laws pertaining to that, so I don't believe it wouldn't be binding law in Tennessee. I just kind of wanted to give you an idea of where I got the reference to what I'll be using a lot in my search terms is the firefighters rule. So that came from that. And let me go ahead and just get to Westlaw here. We can kind of go through some of my search terms, and I'll talk about the cases that we selected for our binding law within Tennessee. And basically, the first search term that we did here was firefighters. Oops. And basically, we in our uh, kind of brain mapping and brainstorming, we came up with some different terms like third party action, personal injury action, negligence, workers' compensation. But really, I felt like this firefighters rule would really apply to our search terms within Westlaw because this deals directly with firefighters getting hurt in the course of their normal job as a firefighter. And we all know that, of course, this talks about the inherent dangers in their job and so forth. So, what really the first case or first search I did was injury for so firefighters rule in injury, and we saw kind of what came up with that and looked through it, and actually we got our two cases actually here, Jamison Ulrich and Carson v. Hedrick, which actually we uh, reference. And basically, what I could do is just open up the case. It's in Tennessee here. Uh, this was decided by the Court of Appeals of Tennessee, and this was in 2006. So a little bit of background: this was an animal control officer who was attacked by a dog during the course of his job. He was bitten by the dog, and I'm sorry, I'm a little bit tired apparently. He was bitten by that dog in the course of his job, and they applied the police officers and policemen and firefighters rule in this case, and they did find that it applied to police officers and um, firefighters, but it didn't necessarily apply to the animal control officer, um, and in this particular case. So let me see. There was in here. Here we go. Okay. This was what I was specifically looking for under negligence. And it says the policeman and fireman's rule precludes firefighters and police officers from recovering damages for injuries arising out of risk peculiar to their employment. Meaning that we know that a policeman and a fireman's job is inherently dangerous. There is a high risk of injury with those two professions versus someone working at retail establishment, or there was a possibility of different jobs that could be sustained, injuries that could be sustained within those career fields. And so we did go ahead and pick this since it does deal with negligence. We're talking about negligence within our case, and it directly speaks to our case that would uh, that the fireman's job precludes him from recovering damages for injuries arising out of his employment. And we know that he was responding, he was on duty, he was an invitee of the store owner into the business based on an emergency call placed by the store owner to have him come in and investigate a carbon monoxide alarm that was received at his business. He fell through a weak floorboard and was injured during that subsequent investigation. So I felt that that was a really good, strong. This would be a strong case to work in favor of our particular case, and if we go to Carson v. Hedrick here, and in this, um, let's see. Hmm. Oh, okay. And under the negligence here, it says under exception to policeman and fireman's rule, a citizen has duty to refrain from, either by action or inaction, intentionally, maliciously, or recklessly causing injury to police officers responding to citizens' call for assistance. The whole otherwise would be to stretch beyond its logical and justifiable terms. The policy considers supporting the rule. Um, that's kind of not what I was. Oh, I'm sorry. Here we go. I'm looking at the wrong one, of course. And under the policeman and fireman's rule, citizens owe no duty of reasonable care to officers responding to uh, that citizens call for assistance. Such rule is based on public policy consideration. The citizen should be encouraged to summon aid from police officers regardless of the citizen's negligence, and should be assured that compensation for injuries suffered by police, or in this case would be a firefighter in the line of duty, would be borne by the public as a whole, meaning that the public insures the police officer and firefighter against their injury, um, and that should really be sufficient to compensate that firefighter or policeman for his injuries without him going above and beyond, or outside of no negligence on a store owner or property owner's part if to allow him to recover additional um, damages, essentially, or uh, additional monies for damage that he's already been compensated for by the city or the public, is my understanding. And Cherrelle brought up a great idea of looking up for looking for the elements of negligence. Well, we need to discuss that in our research. And she was able actually to find a case, um, and we narrowed the search term down to property owner and liable for injuries. And that brings up I guess it says my oops, I'm sorry. I am very tired and I apparently can't type. Let's see if this will work. And it is actually the Parkerville Holiday Hospitality Franchising Inc. was the case that we chose also. And in this case, it was a hotel patron. His wife was injured by the work of a contractor. And it really speaks to this because under negligence, we know this is a negligence case. And is let's see if I can find what here we go. Under negligence elements, and what Cherrelle was able to find is this under key site 13 negligence. It says persons seeking to prevail against a property owner on a premises liability claim must prove the elements of a negligence claim. In addition, must prove either that the condition was caused or created by the owner, operator, or his agent, or if the condition was created by someone other than the owner, operator, or his agent, that the owner or operator had actual construction notice that the condition existed prior to the accident. And this is a key element in proving negligence because you have to show that the property owner was aware of the condition and let it go on, and that would clearly show his negligence, and that um, he would have a duty of care owed by the defendant to the plaintiff. Those elements would be and the conduct by the defendant falling below the standard of care amounting to a breach of duty to in this case would be the firefighter, an injury or loss by the firefighter, which obviously he broke his leg. Causation and fact, meaning did the store owner bring about the condition that caused the firefighter to become injured, or in this case to break his leg, and was that the approximate or legal cause of the firefighter's injury. And I think that basically uh, uh, these are great cases that me and Cherrelle were able to find. Now Jennifer did elaborate a little bit on her research, which I think is great, and it really coincides with what me and Cherrelle found. And I'm going to go ahead and play her video for you.